Good afternoon. I'm Attorney Katherine Henry. A lot of people are getting really emotional, even really vocal about all that's going on in the state of Michigan right now. There's a lot of people that want to fight the executive orders because they're illegal and they're unconstitutional. And there's a bunch of other people who are calling those people selfish and question everything that we're doing, but they don't actually want to hear the answers. So to both sides of that, to people on both sides, I would ask you to hang in there with me for this video so we can understand why we need to fight these executive orders. And I'm not talking about the biblical perspective that I shared with everyone yesterday or the day before. But I'm talking about our actual laws. So, let's start with Article 8, Section 1 of our state constitution, the Michigan State Constitution. Religion, morality, and knowledge, being necessary to good government and the happiness of mankind. Okay? Religion, morality, and knowledge are necessary to good government. We need to make sure we have the knowledge of why certain government officials and agencies get to do certain actions, why the people should or should not do certain actions, why all of this matters, and what happens in times of emergency, what happens when there's a pandemic. We need that knowledge. It's necessary for good government. So, we've also had in discussions about what the governor is doing with these executive orders by essentially shutting down the legislature on having a voice in these executive orders. There's been a lot of arguments on Facebook and other social media about types of government. So, why does all that matter? Well, the structure of principles and rules determining how a state or country is regulated. That's what a government is. The structure of rules determining how that state or country is going to be regulated. It's also defined as an organization through which a body of people exercise political authority. So the government is the shell, the organization, and it's the mechanism through which us, the people, exercise political authority. So, governmental functions. Government conduct is conduct by government agencies or individuals that is authorized by the Constitution or a statute or another law. That seems simple enough. The government can't act without that legal authority. A little known provision of the Michigan Codified Laws here in Michigan. MCL 8.8 defines what a law is. So the Constitution is clearly either going to be our United States Constitution or the state Constitution of 1963, okay? But then as far as statutes or laws, those entail any public act of the legislature, an initiated law adopted by the people, or an executive order of the governor, not all executive orders of the governor, an executive order of the governor submitted to the legislature pursuant to Section 2 of Article 5 of the State Constitution of 1963 and having the force of law. So, recap. The government gets its powers to act based on a provision that is giving them such power in the U.S. Constitution, our state constitution of 1963, or a law. A law is defined here in Michigan, MCL 8.8, as a public act of the legislature, an initiated law adopted by the people, or an executive order of the governor that is submitted to the legislature pursuant to Article 5, Section 2 of the Michigan Constitution. So, these executive orders are not a public act of the legislature. They are not an initiated law adopted by the people. And they are executive orders, but those executive orders were not submitted to the legislature and following other procedures required under our state constitution, Article 5, Section 2. So, we often say this is a democracy. Well, what is a democracy? A democracy is government by the people. And loosely speaking, that includes government by the people either directly or through representatives. But a pure democracy is a government that is direct participation by the people. The people or community, as an organized whole, wield the sovereign power of government. So we don't have those acting on our behalf. It's just all of us voting on things. That obviously we don't have. So it is often seemed in recent decades here in the U.S. that we have an oligarchy. That's a government in which a small group of persons exercises control. So government by the few. That is what's happening right now. It's turning into that because we have a governor who is saying she's going to issue these executive orders. They're going to be considered the law of the land. We have an attorney general saying those executive orders issued by the governor are the law of the land, and you as law enforcement and local prosecuting attorneys, you have to enforce those. And then we have other entities now getting involved. The Department of Health and Human Services and licensing bureaus that are coming in to say, oh, those executive orders are the law of the land, and so we are going to enforce this upon you. That's an oligarchy. For what it's worth, there are monarchies, which would be a government in which a single person rules, and they might have powers varying from an absolute dictatorship to more of a ceremonial position. There are, in fact, limited monarchies, which the form of government is that monarch's power is subject to constitutional or other restraints. Funny thing is, Governor Whitmer does have constitutional restraints on her actions, but as we'll talk about in a minute, she is violating many of them very clearly. And I hope you read it if you don't trust me. Actually, I hope you read it if you do trust me. So, a dictator. People have talked about this being a dictatorship. In general, a dictatorship is a person, a ruler with absolute authority. And that's exactly what Governor Whitmer is trying to position herself as. The interesting thing, though, is under Roman law, so historically, a dictator is an absolute ruler appointed in an emergency for a term of 6 months, subject to reappointment. But in other words, in special emergencies, in times of particularly grave crisis, a dictator would be appointed to exercise absolute authority, but not for a period beyond 6 months, unless the other powers reappointed that person to continue past that time limit. It's interesting. Very analogous to what's happening here. Even according to our own statutes, the Emergency Powers Act of 1976, the governor is allowed to act under emergency powers for up to 28 days unless the legislature votes to extend those powers, which they did, for another 23 days, ending on April 30th, and then they were not extended after that. So her powers ended April 30th under the emergency powers, and follows along with what they did as far back as Roman law. So what do we have here? Well, we have a republic, a system of government in which people hold sovereign power and elect representatives who exercise that power. Okay, kind of dive into that in a minute. So I went into all that to help you understand exactly what we're dealing with, okay? So people like to throw around all these kinds of terms, legal terms, and in terms of government entities and things, and they don't really realize what they're talking about. Here in the United States, political power is inherent in the people. And specifically in the state of Michigan, we hammered that point home in our founding documents. So let's take a minute, though, and realize that in the Declaration of Independence itself, all of us are created equal, endowed by our Creator with certain unalienable rights. Rights that cannot be separated from us. And among those are life, liberty, and the pursuit of happiness. So to secure those rights, life, liberty, and the pursuit of happiness, governments are instituted among men, deriving their just powers from the consent of the governed. Okay, that's literally the whole basis of our government. This isn't some old document that's just in a museum somewhere that we should go and check out, when we're in DC. No, this is the whole basis of our form of government. So we have the right to life, liberty, and the pursuit of the pursuit of happiness. And these rights are not, you can't separate them from us. And our government is literally created to secure those very rights. It literally exists to make sure that we have the right to our life, our liberty, and our pursuit of happiness. And in doing so, that is how the government derives their powers. We give them consent to do so. So, the preamble to our United States Constitution also talks about the whole reason why we established this Constitution, the whole reason why we have this form of government. And it includes, among many things, to establish justice, but also to secure the blessings of liberty. It doesn't even say the word life in there, and it doesn't say the pursuit of happiness. It literally says to secure the blessings of liberty. The liberty of the people. We, the people of the United States, want to secure the blessings of liberty. Something that shouldn't be taken for granted. And in fact, in the Fifth Amendment and the 14th Amendment to the U.S. Constitution, it is secured to us that we cannot be deprived of life, liberty, or property without due process of law. I know these are all things you heard before, but let's think about this. An executive order being issued to order people to stay at home, wear masks in public, socially distance from themselves, amongst themselves, not being able to open your own business, not being able to go into various governmental offices and access a variety of governmental services. Tons of stuff just stopped. And we've had no due process of law. Not at all. But we also need to look at the 10th Amendment, which says that powers not given to the United States in the Constitution are either reserved to the states themselves or to the people. These are not terms that we're supposed to just, they're not just legal terms. It's not just a bunch of jargon that some people long ago wrote and we can just study it in high school and move on. This literally means us, the people that are in existence right now. And another important point is that Article 4, Section 4 of our U.S. Constitution guarantees to every state a republican form of government, and against domestic violence too. Republican form of government where we give people the authority to act on our behalf as government officials. So, the Michigan Constitution has a preamble that also clearly states that we, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom, our freedom, my freedom to go in public without wearing a mask, Carl's freedom to work in his barber shop, just as he always has, the freedom of people to go into restaurants and sit down and eat at a place of public accommodation and not necessarily having to be 6 feet away from each other or wearing masks. But there's a bunch of other provisions in our state constitution that we should be aware of. Article 1, Section 1 says that all political power is inherent in the people. So, government is instituted for their equal benefit, security, and protection. It doesn't mean the government does things for us, or that the government gets to protect certain people, certain classes of people. It means for our equal protection. And that does not mean that the protection overrides our freedom, because those are literally within inches of each other on the same page. Those are literally separated by one sentence in between. So we have the blessings of freedom. We have all political power inherent in us to secure those blessings of freedom. And then government is instituted to protect us, including protecting those freedoms. We also have Article 1, Section 17 of our Michigan Constitution, which states that we will not be deprived of life, liberty, or property without due process of law. So, again, the government, the governor is saying that she is protecting us. She's protecting life with these executive orders, but she's not protecting liberty, and she's not protecting property, the property of all these business owners that are having to permanently close, among many other things, our liberty. So you cannot protect one aspect at the sake of all the others. It's not an either-or situation. Life, liberty, and property. Article 2, Section 8 deals with recalls. Our state constitution, Article 2, Section 8, deals with recalls because this is a government that the people have the inherent authority. The people. not the government officials, not those that we elected. We do. So right in our Constitution, we have a provision for recalls. Right in our Constitution, we have a provision for removing of officers. Article 5, Section 10. We also have Article 5, Section 30, which provides term limits for executive offices. Article 4, Section 54 provides term limits for legislators. Article 6, Section 2 provides term limits for justices. Article 6, Section 9 provides term limits for Court of Appeals judges. Section 12 provides term limits for circuit court judges. Section 16 provides term limits for probate court judges. Section 25 provides for the procedure to remove judges. So we have right in our Constitution the ability to recall, the ability to remove officers, term limits in place, and the ability to remove judges. Why? Because political power is inherent in the people, not the government, and not the government officials. So let's not forget, though, about Article 11, Section 7, which additionally gives us the ability to impeach civil officers, and the whole procedure is written out there. So we can recall, we can remove, we limit their tenure from the very beginning, and then we can impeach, because political power is inherent in the people. So Article 11, Section 1 of our state constitution provides an oath. The oath of everyone serving in a government capacity, that they are going to uphold the Michigan and U.S. constitutions, meaning all of these provisions we just talked about, everything I've talked about up to this point, that everyone in government has to uphold those U.S. and Michigan constitutional provisions, including the limits on their own exercise of authority. So why is this all relevant? Are people like me just making a big deal about nothing? Are we trying to make this whole situation seem super extreme when all the government is trying to do, all the governor is trying to do, is to care for people and keep us safe from COVID-19? Well, if you read the Declaration of Independence, one of the very things that they cite as a reason for needing to declare independence is that the powers that be had suspended the legislatures and declared themselves invested with the power to legislate for them. Suspending our own legislatures and declaring themselves invested with power to legislate for us. That's exactly what these executive orders are doing. It's essentially by her exercising this emergency power after April 30th, when the legislature said no more, she has essentially set aside the legislature entirely and declared herself the one who is able to enact laws or exercise legislative power. That's why we left and declared our freedom in the first place. These are huge concepts. This is not a bunch of people just complaining when we all just need to hang in there and realize that we're in this together. Yeah, we're in this together, and we should be recognizing that our freedom, our very freedom, is at stake here. So this freedom is the very reason why, and the fact that all of these provisions that demonstrate how the political power is inherent in the people, that leads to why we have a separation of powers. In our state constitution of 1963, Article 3, Section 2, very clearly states there's a separation of powers, and no person that's serving in one branch can exercise the powers belonging to another branch. So if the Chief Justice of the Michigan Supreme Court is serving in the judicial capacity, she can't then try to exercise the powers of a governor, because that would be the executive branch. Likewise, our governor, who is clearly in the executive branch, cannot, while exercising those powers, try to exercise the powers of the legislature. She can't create laws. She cannot issue executive orders that put restrictions upon the people that have the effect of law, because our Constitution says so. I didn't say so. That's what our Constitution says. Additionally, Article 4, Section 1 of our state constitution specifically spells out that the legislature has the legislative power. The legislature of the state of Michigan has the power to create laws. Article 5, Section 1 specifically says that the governor has the executive power. There are other executive branch officers, but the executive power is vested in the governor. That's the term, that's literally the words of the provision there. Article 6, Section 1 states that judicial power rests in our courts. So we have a separation of powers. It's totally obvious, okay? You can't exercise power in more than one branch. But we also need to remember that this is a government of the people, so we need the people's participation in that government. Well, Article 4, Section 20 of our state constitution requires there to be open meetings of the legislature so that the people can participate. We also have various acts on point, statutes. The Freedom of Information Act. It is an act to provide access to public records of public bodies. And it is the public policy of this state that all people are entitled to full and complete information regarding the affairs of government and official acts of those who represent them as public officials and public employees. Specifically, the people shall be informed so that they may fully participate in the democratic process. That's the public policy of our state. It's in the laws. I'm not making this stuff up. We also have things like the Open Meetings Act. That act, also of 1976, requires meetings of certain public bodies to be open to the public. It requires notice. It requires them to keep minutes of the meetings. And it even provides for invalidation of governmental decisions that violate this act. Something interesting to keep in mind is that these two acts and the Emergency Management Act were, I'm going to just double check before I say that. Yes. The Freedom of Information Act, the Open Meetings Act, and the Emergency Management Act were all enacted in 1976. So let's think about that for a minute, because it's the same people, the same legislators who enacted a policy of full government participation and of openness. And those are the people that created the Emergency Management Act. So one would think that they're not going to allow a governor endless powers for emergency situations in one act, while saying that the people need to be able to participate and have full and complete access to what's going on in government. We also have the Enhanced Access to Public Records Act of 1996. It's calling for immediate availability for public inspection of public records. We also have the Electronic Open Access to Government Act of 2016, which is an act that provides for public electronic access to information through the state's website, to require posting of information, to require that the names of people in office and organizational charts are posted online. All of these things, all of these acts go to the premise that this is a government of the people. This is not a government where we have a governor, an attorney general, or judges, or anyone else who gets to just act on their own and without being held in check by the people. We also have Article 4, Section 24 of our state constitution that requires laws that are enacted to cover no more than one subject at a time. So, in other words, if we were going to argue that these executive orders could legally place restrictions upon us as people, then they would have to, at the very least, not cover all these topics. They can't cover shutting down our travel. They can't shut down places of amusement or places of public accommodation. They can't shut down our livelihoods by stopping us from going to work and running our own businesses. They can't require us to wear masks in public or to social distance. They can't stop our access to certain government functions or offerings. Every single one of these executive orders covers a variety of different topics, but that violates Article 4, Section 24. We also have another provision in our state constitution that goes to enhancing the people's participation in our government. And that is that anytime our laws are modified in any way, that change to the law cannot just be published on its own and put in the Michigan Codified Laws. No, if the law is changed, the entire law has to be reprinted or republished with the changes in it so that you see it in context, so that we have the information in context. We have all the information we need in order to understand it, in order to be able to participate fully in our government. So that's Article 4, Section 25. But we also have Article 4, Section 27. That requires the governor to wait 90 days before enforcing any new laws or legally enforceable executive orders unless the legislature has done something to specifically enable that immediate enforcement. I believe it's a vote by 2/3. I don't have that off the top of my head. Yes, 2/3 vote. So it takes 2/3 of the legislature to vote in favor of giving a law immediate effect. So if we're going to say these executive orders have the effect of law and we can be punished in law with misdemeanors, with civil infractions, with licensing violations, having our business licenses pulled, that if we're going to have those legal enforcement provisions against us, then it has to have the enforceability of law, meaning you have to wait 90 days before you enforce such a law, unless the legislature has voted by a 2/3 majority to give it immediate effect, which they did not. So what about in times of emergency? A lot of people are saying that, right? Oh my gosh, this is a pandemic, for crying out loud. What are you guys so worried about your rights? This is temporary. This doesn't do anything to your rights. Everything's just temporary. We're going to get our rights back. We'll be able to go to restaurants and go to movie theaters and open our businesses. And, you know, this is just super serious. People are dying, and it's a time of emergency. Okay? I hear you on that, but we've always had emergencies. We've always had people dying. Always. Certainly our founders of this country knew times of disease, of famine, of hardship, and yet nothing in our Declaration of Independence says, well, we have these freedoms, we have these unalienable rights, except in times of emergency. When we need the government to come in and save us, then we don't need life, liberty, or the pursuit of happiness. No, that's not what it says. It also doesn't say that in our U.S. Constitution. In fact, if you look at the language of, for example, our First Amendment rights, it says right in there that there can be no law abridging those very rights. Our rights are unabridged. We have to exercise them unabridged. And our state constitution also does not allow our rights to be set aside, even temporarily, even in a state of emergency. Nowhere in there does it say that it's okay to set aside our rights in a state of emergency. In fact, our preamble says that we created this very Constitution to secure the blessings of freedom. It doesn't even say secure the blessings of life and property and the pursuit of happiness. No, it says secure the blessings of freedom or liberty. Undiminished. Let's not forget that word. We're securing our blessings of freedom undiminished. There cannot be a law, a statute, a public act by the legislature, an executive order of the governor that diminishes our rights, even temporarily, for any reason whatsoever. And if you don't like that, I didn't write it, it's here. I mean, you can move somewhere else, but that's what our Constitution says. Also, Article 4, Section 39 of our state constitution has an entire provision called Continuity of Government in Emergencies, where the provision is meant to ensure the continuity of government operations. So we have the judicial branch, the executive branch, the legislative branch, all functioning in their capacities to continue that checks and balances, the separation of powers, to make sure that we have the functions of government, since our government is created to secure our blessings of freedom. But let us not forget this Emergency Management Act of 1976, the one that she references in all of these executive orders. In fact, side note, it's also the only statute she references in all of the emergency orders, declarations of state of emergency that she issued in all of 2019. She never once references the 1945 Emergency Powers of Governor Act. At any rate, MCL 30.421 is part of the Emergency Management Act. Clearly states that even in a heightened state of alert, not just a normal emergency, not just a normal state of emergency, but a heightened state of alert, with an even greater exercise of these powers, constitutional protections must still be preserved. Specifically, the governor's powers under the Emergency Management Act shall be consistent with the provisions of the state constitution of 1963 and the federal constitution. So that's the very wording of that act. So, and it doesn't just say in terms of our First Amendment rights or Second Amendment rights, it literally says with all the provisions of the state constitution and the U.S. Constitution, separation of powers, the way to enact laws, all of the things that we've talked about. Also, the same statute prohibits prosecutors from prosecuting violations of these executive orders in any manner, quote, manner that violates any constitutional provision. Also, prosecutors are prohibited from prosecuting violations of these executive orders for conduct presumptively protected by the First Amendment to the Constitution of the United States. Well, considering that the Attorney General of the state of Michigan, Dana Nessel, literally wrote that the whole point of all of these executive orders is to, how did she word that? To keep the people away from each other. I'm pretty sure was her exact wording. To keep the people away from each other, because that's what they've deemed as necessary to stop the spread of COVID-19, which, by the way, definitely is not a well-founded scientific fact at this point, but whatever. So the whole point is to keep people away from each other. Yet those same people, us, we have the constitutional protections allowing us and guaranteeing us general liberty, but also specifically the right to peaceably assemble, to worship, to petition the government for a redress of grievances, to speak publicly. So we can't have executive orders whose sole focus is to keep the people separated from each other. So what about laws or executive orders that violate the U.S. or Michigan constitutions? I'm going to bring you back to that Michigan Constitution, Article 11, Section 1, Oath. So, in fact, let's get specific. I don't want you to take my word for it. All officers, legislative, executive, and judicial, before entering upon the duties of their respective offices, shall take and subscribe to the following oath or affirmation. I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office of, fill in the blank, according to the best of my ability. Notice that they are not swearing to support the laws of the state of Michigan. Why is that? Well, because some laws might not be able to be enforced. Some laws violate the U.S. or Michigan Constitution and are therefore unenforceable. So we can't put our public officers in a predicament where they have taken an oath to uphold both the Constitution and the laws if the laws sometimes are enacted in such a manner that violates the Constitution. No, the oath requires them to uphold the U.S. and Michigan Constitutions. So they have to faithfully discharge the duties of office. So if you're in the executive branch, then you are supposed to be enforcing the laws as written. Obviously, if they are in accordance with the U.S. and Michigan Constitutions. But no matter what, no law and no executive order may violate the U.S. or Michigan Constitutions. Period. So if you're going to say that a certain law can be read in a way to deprive us of our rights to peaceably assemble, to collectively worship, to have liberty or freedom, the blessings of liberty given to us by our Creator, I'm sorry, but you are wrong. because our Constitution, our Declaration of Independence, even the very statutes involved, all bring us back to the point that this is a government by the people, where the people hold the ultimate authority. And we have representatives in this Republican form of government. We have people that represent us and only are allowed to exercise such authority to the extent that they are lawfully given that authority. If the Constitution says they cannot do something, it doesn't matter if they say they can. It does not matter if you want them to be able to do it. It does not matter if an executive order says that we can do it. If the Constitution does not allow it, then it can't happen. So I hope that you consider all of those points and you look up those provisions and you think about why we have a responsibility here. Looks like I do have some questions though. Is the battery good?
30%.
Okay.
29%.
Do I know when the judge is going to rule? As of 3 minutes before we went live, the judge had not ruled. I really thought it would have been issued by now, so I'm really surprised. But I still expect that it's going to be very soon. What about sending out over 7 million absentee voter applications? Well, I haven't gotten one. I don't know if you've gotten one. I didn't even get the opportunity to vote absentee in my local election on May 5th, May 4th, first Tuesday in May this year. And I even contacted both my county clerk and my township clerk about that. And the county clerk directed me to my township clerk, and the township clerk directed me to the Secretary of State. So that's a whole nother conversation. Why is it so hard to put her in her place? I'm assuming that question is meant for the governor. Why? Well, because the people are not standing up. If the people as a whole exercised the freedom guaranteed to them in the very form of government we have created, there would be no problem. If the chief law enforcement officer of the state, i.e. the Attorney General, Dana Nessel, if she was abiding by her oath of office, then she would be putting her in her place. If the courts were taking this duty seriously, we wouldn't have decisions that deny preliminary injunctions, which, by the way, is all that happened in the order that was issued, I believe, yesterday in the Court of Claims by Judge Kelly. It was a motion denying the request for a preliminary injunction to be issued. Similar to that which happened, I believe, on April 28th, in a similar case, when everybody freaked out and said, "Oh, but the governor just won. She has the right to do everything she wants." Nope. And guess what? It honestly, in the end, it doesn't matter if a judge says the governor has the right. They could write the very words in their court order. The governor has the right to do whatever she wants because this is an emergency and she has issued executive orders. They could write that very wording on a piece of paper and make it an official order of the court. And guess what? It would be meaningless because the Constitution of the state of Michigan and the Constitution of the United States and the Declaration of Independence clearly do not allow that to happen. Our statutes don't even allow that to happen. So let's just keep that in mind. Our judges are not in the position of God. God gave us our rights. The government, including the judicial branch, is instituted to protect those very rights. I read that she declared a state of emergency for the county that has the flooding. How can she declare a state of emergency for counties that don't have cases right now or that never even had outbreaks? Right. So, that is a very good question. Quite honestly, I don't think she could do that. Quite honestly, I think there are literally dozens of ways that she violated the statutes and the Constitution in addition to what I've already shared with you today. but I didn't want to put people to sleep. So I don't think she can. What my argument has been is let's assume that everything was totally legal up until April 30th, that she could put the whole state under a state of emergency and lock us down. Let's assume that just for the sake of argument. Even so, after April 30th, it's gone. There is no such emergency. There is no such emergency power according to the very terms of our laws. If our state police are our emergency team, isn't their job still to uphold our Constitution? Isn't this a conflict of interest? Well, there's no conflict of interest because above all else, the state police have to enforce the Constitution of the state of Michigan and the Constitution of the United States. They take the same oath of office. They have to swear to support the Constitution of the United States and the Constitution of this state. They don't swear an allegiance to a governor, an attorney general, a secretary of state, a certain president, a certain judge. They swear an allegiance and an oath to upholding the constitutions as they are written. So there is no conflict of interest. Anyone who would view it as a conflict of interest hasn't read the Constitution, at least not enough. So I would encourage, if you are in law enforcement and you feel conflicted, you feel like there is something that is requiring you to enforce these executive orders upon people, but yet you recognize that the Constitution basically says that you can't, just remember the Constitution is supreme above all laws, executive orders, or directions from your superior officer. The Constitution is, and you took an oath to uphold that Constitution. You did not take an oath to abide by the orders of your superior officers or the executive orders of the governor or of anything else. You took an oath to uphold simply the terms of the Michigan Constitution and the U.S. Constitution. Are we going to appeal today's decision? I guess I wasn't aware of a decision that happened today. I know that late yesterday there was a decision made in the Michigan United for Liberty case where they were suing the governor. Again, that was a request for a preliminary injunction against the governor, and that request was denied, but that's all. The lawsuit of the legislature versus the governor, no order has been issued today, at least by the close of business, and several other lawsuits that I've been keeping an eye on, I didn't see any orders issued today, so I'm not sure what order that would be or if that would be appealed. I can talk about appeals in a minute, but quite honestly, I should probably answer that in a different video so this doesn't go on any longer. Okay, that's appeals. What right did Michigan State Police have to ticket hairdressers in Lansing today? Well, assuming that the only rules or laws or orders that those hairdressers were violating were the executive orders of the governor, things relating to COVID-19. If those were the only violations that these hairdressers committed, the state police did not have any right or authority to enforce those executive orders, not one bit. And every single one of those Michigan State Police, they violated their oath of office. They stepped outside of the bounds of their governmental authority. They thus opened themselves up for claims of malicious prosecution, criminal and civil, abuse of process, which is civil, and possible claims under, I think it would be 42 U.S.C. Section 1983, acting under color of law, and I think it would also be, is it 18 U.S.C. Section 241 and 242, I believe. So, yeah, if you're in law enforcement, please be careful. Please do not go with the whole, well, I was just following orders. That doesn't cut it. That's not the kind of government we have to do. Even if you're going to be the only state police officer to disobey the chain of command and instead support and defend the U.S. and Michigan constitutions, by all means, please do it. And guess what? If you are going to be that loan officer in your department or loan deputy in your department or what have you, you're the only one in your workplace, so to speak, and you have sworn that oath to uphold the U.S. and Michigan constitutions, but you are afraid or you are nervous because you are the only one that wants to do so, please reach out to me. We will have millions of people supporting you. We will certainly have thousands of people who will be reaching out in one way or another to your superior officers to tell them that they support and commend you for doing what you swore an oath to do, which is uphold the U.S. and Michigan constitutions. You're not alone. You might be alone in doing so within that department, but you are not alone. There's a lot of us who are going to step up and support you in every real and practical and legal way possible, in ways that you have never imagined having support. So please reach out. Reach out to me. Find me on Facebook. Call me, text me, email me. Some of you already have. Some law enforcement officers, some prosecuting attorneys and city attorneys have reached out to me to say that they are defending the Constitution and not enforcing these executive orders. And I commend you. But if you need support, please reach out to me and we will provide that support, undoubtedly. Can we remove Gretchen Whitmer from office before we vote? I'm assuming that means before the next set of general elections. The problem is, if we remove her, I did a whole video on this, I believe it was yesterday. If we remove her, we don't get to pick who goes in there. It would be the lieutenant governor would be the next person in place. And I want to say it's Article 5, Section 26 of our state constitution that says that. So it's not like any other recall. It's not like any other impeachment proceeding. If she's removed from office, the lieutenant governor would serve in her place, then the secretary of state, and then the attorney general, if, none of them were able to do so. It would go in that order. I believe we have then a state statute on point, which I did not print out, but we do have a state statute that then says if any of those three are not able to serve as governor, then it would move to the Senate Majority Leader and then the Speaker of the House of Representatives. But you got to go through all those other people first. We don't get to pick. So I don't know that you really would want to have her removed from office. So I think those... Oh. If it goes to the Michigan Supreme Court, how long would this take? I'll tell you what, I am going to do another video specific to all the questions regarding the lawsuits happening. The long and short of it, the summary is that there's nothing that you need to know right now. There's nothing that has happened right now that changes anything that I've said to you in any of these videos. Not one thing that's happened in court in any of these lawsuits. Okay? And as soon as we have something that comes down from the judge in the lawsuit between the legislature and the governor, I'm definitely going to update you. And I can answer all those other questions. I can answer what the process is, the procedure from, appealing, depending on what her decision looks like. If it's a final judgment or final order, then it's an appeal of right to the Court of Appeals. If it's not a final order, then it's they have to ask for leave or they have to ask for permission to appeal to the Court of Appeals. There's also a court rule that allows them to ask the Supreme Court to intervene before the Court of Appeals has even ruled on the situation. And those are all things that we could talk about. I can go into detail, but at this point, nothing has happened that changes any of the other things I've done in these videos. Nothing. Every single executive order is still unenforceable as a matter of law and of the Constitution. And the police officers, the Michigan State Police, your local police, they can't legally pull your business license or issue citations for criminal infractions, and they cannot issue citations for misdemeanors legally. Now, can they physically do that? Yeah, they've been doing that. Is it going to hold up? No. Is it constitutional? No. If the only thing you have done is violate these executive orders, there's no basis in law whatsoever. Okay? So, so far, I've answered all the questions, like I said, except for those that are specifically going to things relating to the lawsuits, and I'll do that in another video. But stay watching the page, and I will keep you updated as best I can. Thanks.